Welcome to AutoNoFaultLaw.com and to the utilization review pages. My name is Katie Tucker and I'm an attorney at the Lansing office of the Sinas Dramis Law Firm. I focus my practice on representing injured persons and their medical providers in pursuing and recovering unpaid no-fault benefits under Michigan's no-fault law. I'm preparing and presenting all of this to you today to share more information about a brand new feature of Michigan's no-fault law that affects patients and providers alike, and that is utilization review. And utilization review is governed by Diffs' new utilization review rules, which set forth a three-stage process, which you can learn more about by visiting our other pages from the ANFL website. But I want to talk with you now about some of the frequently asked questions I've been getting from my clients and from others who are affected by the new rules and the new process, and to give you some answers to those questions, to give you some guidance as you move forward and navigate this new territory. So with that, I'd like to get started with sharing a PowerPoint that I have prepared on some of these frequently asked questions and some answers for all of you. So one of the first questions, or most common questions that I've received, is this: are case managers, guardians, transportation providers, and others that render ancillary services to auto accident victims or services that otherwise fall outside the category of medical care subject to Diffs' new utilization review rules and to the new UR process? And the answer to this question is yes. The rules broadly define a provider as a physician, hospital, clinic, or other person providing treatment, training, products, services, and accommodations to an injured person. This definition is actually explicitly set forth in Rule 61M. A link to the rules is also available from the ANFL website, and I encourage you to read the rules in their entirety. But certainly this broad definition is expansive enough to include any individual who's providing any service to an individual who's been injured in an auto accident in Michigan. Another frequently asked question that I have received is this: can an insurer or the MCCA utilize, use, or contract with a medical review organization, commonly referred to as a third-party audit company, to perform utilization review activities? And again, these medical review organizations or third-party auditing companies are ones like ReviewWorks, Corvell, MedAudit, and many others that you may be familiar with. So the question is, can insurance companies or the MCCA still use these companies? Well, I think again, the answer here is yes. The utilization review rule suggests that an insurer or the MCCA may contract with the medical review organization to conduct utilization review activities. Specifically in this regard, Rule 62D provides that nothing in the rule should be construed to limit the ability of insurers and the Catastrophic Claims Association to contract with the medical review organization to perform utilization review activities on their behalf. Very importantly, however, even if an insurer or the MCCA elects to contract with an outside external medical review organization, again, think here of ReviewWorks, Corvell, MedAudit, and many others, the insurer or the MCCA remains fully liable and responsible for satisfying its obligations under the No-Fault Act and related administrative rules. In this regard, Rule 62D also provides that an insurer that uses a medical review organization remains responsible for complying with the Act and any rules promulgated thereunder. So essentially the answer here is yes, an insurance company or the MCCA may contract with or use an external auditing company, medical review organization to perform utilization activities, review activities on its behalf, but ultimately the buck stops with the insurer or the MCCA to satisfy its obligations under the no-fault law and under the rules promulgated thereunder, including these Diffs utilization review rules. Another question that I've been asked frequently with regard to the utilization review rules and process is, must a provider retain copies of all of these utilization review related records? So with the advent of the ability of insurance companies to request written explanations from providers, including bills, records, other information concerning the treatment, and providers having the obligation both under the rules and under the statute to supply all of this information, there is bound to be a lot of paperwork exchanging hands. So the question is a medical provider or an insurance company responsible for maintaining copies of all of those records, all of that information? Again, here the answer is yes. Providers are required to retain copies of utilization review related records for at least 2 years. Specifically, Rule 69 of the UR rules addresses this issue and provides that insurers, the association, and providers must retain copies of all requests, explanations, and determinations issued under these rules for at least 2 years after the date, and they must be able to submit them to the department upon request. So medical providers are encouraged to maintain an internal tracking system, an internal storage system for maintaining all of these and retaining copies of all of these records for further review. Another frequently asked question that I've received with regard to the new UR process and rules is the Diffs appeal process the only mechanism for a provider to challenge an initial determination by a no-fault insurer or the MCCA? In other words, is the Diffs appeal process the only avenue by which a medical provider can challenge a denial of payment of its bill by an insurer or the MCCA? And the answer to this is no. The amended version of the no-fault law, which took effect on June 11, 2019, and came into existence with the passage of Public Act 21, also clearly permits a provider to file a lawsuit in a Michigan trial court to challenge an insurer's denial and to pursue recovery of unpaid no-fault benefits. And the right to pursue a civil action in a Michigan trial court is specifically guaranteed by Section 3112 of the amended version of the no-fault law. Under that section, a healthcare provider listed in Section 3157 may make a claim and assert a direct cause of action against an insurer to recover overdue benefits payable for charges for products, services, or accommodations provided to an injured person. So it is clear that the legislature has vested medical providers in Michigan rendering treatment to auto accident victims with the authority and ability to file and pursue a direct cause of action or a civil lawsuit in a Michigan trial court to recover unpaid no-fault benefits. So this is another avenue available to a provider aggrieved by a decision by Diffs, or I'm sorry, a decision by an insurance company or the MCCA for recovering unpaid no-fault benefits. Importantly, too, the Diffs rule that governs appeals makes clear that the appeal process is not a provider's only recourse insofar as it uses this permissive language of may. So under Diffs UR Rule 65 sub 1, a provider may appeal a determination made by an insurer, the association, to Diffs on a form prescribed by Diffs. But importantly, the rule does not require a provider to do so. And from this, an inference can be drawn that the Diffs appeal process is just one other potential avenue of recourse for a provider aggrieved by a decision of or an initial determination by an insurer, the MCCA. Another frequently asked question is also somewhat related to that, which is, does the UR appeal process include an evidentiary hearing or other opportunity to present witnesses or oral argument to Diffs? And the answer to this is no. There is no contested hearing or any other opportunity to present an oral argument or witnesses to Diffs as part of the appeal process set forth in the new utilization review rules. Instead, the rules are very clear that the Diffs director shall make her decision in this case based solely on the written material submitted by the party. So there's no opportunity to present to make any verbal presentation to Diffs or to present any oral argument or the testimony of any live witnesses. The Diffs director shall make her decision based solely on the written material submitted by the parties. And last, another frequently asked question that I have received is a provider required to comply with a decision of Diffs? And this being asked in the context of Rule 65 sub 7, which does make clear that the decision of Diffs is ultimately subject to judicial review. But is a provider required to comply with a decision of Diffs? The answer to this is yes. Under Section 3157A of the no-fault law, by rendering any treatment, products, services, or accommodations to an injured person, covered by personal protection insurance under the no-fault law, a physician, hospital, clinic, or other person is considered to have agreed to comply with any decision of the department, meaning the Department of Insurance and Financial Services, under this section, under section 3157A, which governs utilization review. So because of this language, which again comes directly from the statute, it is very clear that a medical provider, by rendering treatment to an auto accident victim in Michigan, must agree or is considered to have agreed to comply with a decision of Diffs under this utilization review process and under the new rules. And so with that, I hope I've answered some of the questions that you may have. These are some of the frequently asked questions that I've received. If you have any additional questions that you would like to get answers to, I encourage you to submit those to the ANFL editorial board through our website and the email address that's provided on our website, and we will look forward to answering those for you. Thank you for your time, and I hope that this has been helpful.